Daf Yomi, Daf Yomi, Daf Yomi. Tractate Shevuot 32a, top of the page. Daf Yomi, Daf Yomi, Daf Yomi, Daf Yomi. Ay, 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 ay. Shevuot, Shevuos, 32, top of the page with the words Ad sheyishmeu mipi atovea, until they hear a demand to testify directly from the mouth of the plaintiff. Ratzacharein itzrichalei salkadai techamina kevan ratzacharein kimanda maluhu deme kamashmala. The Gemara answers, mentioning the case of the plaintiff pursuing them was necessary for Shmuel, as otherwise it could enter your mind to say, since the plaintiff is pursuing them, it is like the case of one who says to them directly to testify. Therefore, Shmuel teaches us that, although the intent of the plaintiff is for them to testify, the witnesses are liable only if he tells them so explicitly. V'hana mitanina Shevuos eilus ketzad amor le'edim pa'u v'hiduni Shevua kule amar in lo amar la. The Gemara asks, but this too we learned in the Mishnah, liability to bring a sliding scale offering for taking a false oath of testimony. How so? In a case where the plaintiff said to two witnesses, "Come and testify on my behalf," and they replied, "On our oath," etc., from which it can be inferred that if the plaintiff said this to the witnesses, yes, they are liable, and if he did not say this to the witnesses, no, they are not liable. Amar lav dafke. The Gemara rejects this. No proof may be cited from the Mishnah, as perhaps when the Tana states in a case where the plaintiff said he did not mean that this is the halacha, only in a case where he specifically verbalized his demand that they testify. Rather, the same would be true even if he conveyed his intent in a non-verbal manner. Di'i la temahachi gavi pikadon dikatani Shevuot hapikadon ketzad amar lo ten li pikadon sheyesh li biyadecha achanami amar in la amar la ha b'chichash be'amito kol dehu. As if you do not say so and assert that the language of the Mishnah is precise and one is liable only if the oath was in response to a verbal demand, then, as for the Mishnah 36b, which teaches with regard to a deposit, liability to bring a guilt offering for taking a false oath on a deposit, how so? In a case where the owner said to the bailee, "Give me the deposit that belongs to me and is in your possession," would you say there also that if the owner said this to be the bailee, yes, he is liable, and if he did not say this to the bailee, no, he is not liable? But doesn't the verse end deals falsely with the colleague in a matter of deposit? Leviticus 5:21 indicate that the bailee is liable for any denial of the deposit at all, unrelated to the nature of the claim raised by the owner of the item. Ela amar lav dafke, achanami lav dafka. Rather, it must be that when the Tana says with regard to the oath on a deposit, in a case where the owner said to the bailee he did not mean that this is the halacha only in a case where he specifically verbalizes his demand. Here too, with regard to the oath of testimony, the Tana did not mean that this is the halacha only in a case where the plaintiff specifically verbalized his demand. Haimai I amar bishlama amar dahadavka tada asam atuhacha ela I amrit la amar dehasam davka velo amar dehadavka amar lamali lemisne. The Gemara asks, what is this comparison? Granted, if you say that here, when the Tana says in the Mishnah with regard to the oath of testimony, in a case where the plaintiff said to two individuals, it is specifically in a case where the plaintiff verbalized his demand, one could explain that the Tana taught there with regard to the oath on a deposit in a case where the owner said, due to the fact that he employed that formulation here in the Mishnah, Tanaim frequently employ uniform language in different cases, even though there are halachic differences between them. But if you say that neither there, with regard to the oath on a deposit, is specifically in a case where the owner verbally said, nor here with regard to the oath of testimony, it is specifically in a case where the plaintiff verbally said, why do I need to teach? Said in both instances. Dilma, O Chadimin Sakamash Malan. The Gemara answers, perhaps the Tana is teaching us the matter in the manner in which it typically occurs, as both the plaintiff and the owner of a deposit typically articulate their claims verbally. It may still be that if the demand was conveyed non-verbally, the witness is liable, since there is no proof from the Mishnah. The statement of Shmuel is necessary to teach that if the demand is not articulated verbally, the witness is not liable for taking a false oath. Tanya kavasei Shmuel, ra'uhu sheba acharehen, amar lo, ma'ata ba achareinu, Shvua she'enanu yoidin recha edus beturin bim bikadon chayohin. The Gemara notes that it is taught in a Braita in accordance with the opinion of Shmuel in a case where the witnesses saw that the plaintiff was pursuing them, and they said to him, "For what reason are you pursuing us? On our oath, we do not know testimony on your behalf. They are exempt." And if it is with regard to an oath on a deposit, in a case where the owner is pursuing the bailee and he denies that the deposit is in his possession, the bailees are liable, as they are liable for any denial of the deposit at all, irrespective of the nature of the claim raised by the owner of the item. The Mishnah teaches, if he administered an oath to them 5 times, and they came to court and admitted that they had knowledge of the incident and testified, they are exempt. But if they denied knowledge of the incident in the court as well, they are liable for each and every one of the oaths administered to them outside the court. The Gemara asks, from where do we derive that it is specifically for denial in court that they are liable, and they are not liable for denial outside court? Amar Abaye, Amar Ko im lo yagid v'nasa avono. לא אמרתי לך אלא במקום שאילו מגיד זה מתחייב זה ממון. Abaye said, it is derived, as the verse states, with regard to the oath of testimony. If he does not utter it, he shall bear his iniquity. If he does not utter it, he shall bear his iniquity. Leviticus 5:1, from which it is derived, I said this halakha to you only in a place where, were this witness to utter his testimony, that other individual becomes liable to make a monetary payment, meaning in court. He is not liable for denial in a place where his testimony would not render one liable to pay. Amalei Pabale Baye Hachi Ema Shevua Gufa Bebez Dinin Veshelo Bebez Din La. Rav Papa said to Abayah, if so, say that it is not the denial but the oath itself. If it is taken in court, yes, he is liable, and if it is that which is not taken in court, no, he is not liable. Lo sol kedaitach litanya leachat lechayev al kol achas v'yachas v'sol kedaitach bebeis din mi mechayev al kol achas v'yachas v'etzanan yishbia lehen chamisha פעמים בפני בית דין וחפרו, אין חייב אין האחס, אמר בשמעון, מה טעם? הואיל ואינם יכולים לחזור להוידוס אליו שמע מינה שבועה חוץ לבית דין כפירה בבית דין. Abai said to Rav Papa, that should not enter your mind, as it is taught in a Braita that the verse, and it will be when he is guilty of any one of these. Leviticus 5:5 serves to render one liable to bring an offering for each and every instance when one repeatedly performs the transgressions for which one is liable to bring a sliding scale offering. And if it enters your mind that one is liable only for an oath taken in court, one is liable for each and every oath. But didn't we learn in the Mishnah, if he administered an oath to them 5 times before the court, and they denied knowledge of any testimony relating to the incident, they are liable for taking only one false oath. Rabbi Shimon said, what is the reason for this ruling, since once they denied that they had any knowledge of the matter, they can no longer retract that denial and admit that they have knowledge of the matter. Rabbi explains, rather, must one not conclude from it that one is liable for each and every oath taken outside court, but one is liable only if the denial is in court? Kafu shnein kachas chayovin hadi efshar litzamtzem. The Mishnah teaches if both of the witnesses denied knowledge of the incident together, both of them are liable. The Gemara asks, but isn't it impossible for 2 events to coincide precisely? By necessity, one denial must have preceded the other. Rav Chisda said, in accordance with whose opinion is this Mishnah? It is in accordance with the opinion of Rabbi Yossi who says it is possible for 2 events to coincide precisely. Rabbi Yochanan Amar, Filutema Rabbanan, Kegon Shekaf Kushne Betoch Kadei Dibur, Betoch Kadei Dibur, Kadibur Dami. Rabbi Yochanan said, even if you say that the Mishnah is in accordance with the opinion of the rabbis who disagree with Rabbi Yossi, the Mishnah can be interpreted in a case where both of them denied knowledge of relevant testimony within the time required for speaking a short phrase, and the halachic status of a pause or retraction within the time required for speaking a short phrase is like that of continuous speech. Although the 2 statements did not coincide precisely, their halachic status is as if they did. Amar le Rava chamidifti le Ravina mechdi mitoch kedei dibur kama habe kedei she'ela tamid lerav ikede amri kedei she'ela terav letalmid ad amri shvua she'en anu yoidin lecha edus tuvahavi amale kol echad leechad toch diburo shel chaveiro. Rav Achav Difti said to Ravina, after all, how long is the duration of within the time required for speaking a short phrase? It is an interval equivalent to the duration of the 3-word greeting of a student to his teacher, Shalom Alecha Rabbi. Some say that it is a briefer interval, equivalent to the duration of the 2-word greeting of a teacher to a student, Shalom Alecha. According to either opinion, in the time that elapses until the two of them say, "On my oath, we do not know any testimony for you," it is an interval greater than the time required to utter those words. How then can the Mishnah be interpreted as referring to a case where they stated their denials within the time required for speaking those words? Ravina says, Ravachav Difti, the case in the Mishnah is one where each and every potential witness will issue his denial within the time required for speaking, starting from the end of the statement to the other. Harishon chayav, hasheni patur. Masnisin de la ki haitana, petana mashbiya ed echad patur. The Rabbi Elazar and Shimon Mechaye, the Mishnah teaches, if they denied knowledge one after the other, the first one who denied knowledge is liable, and the second one is exempt, as once the first witness denies knowledge of the incident, the second is an individual witness whose testimony is not decisive, and he is exempt from the oath of testimony. The Gemara notes, the Mishnah is not in accordance with the opinion of this Tana, as it is taught in a Braita in the case of one who administers an oath. To one witness, the witness is exempt from bringing an offering for taking a false oath of testimony, and Rabbi Elazar, son of Rabbi Shimon, deems the witness liable to bring an offering. In his opinion, the second witness in the case of the Mishnah would be liable, not exempt. Lema behakamiflegi demal savar eid echad kiyasa Shevuot hu dikaase umal savar eid echad kiyasa limamona kaasa. The Gemara suggests, let us say, that they disagree about this. One stage, the first Tana holds, when one witness comes to testify, it is to render the one against whom he is testifying liable to take an oath, and that is the reason that he is coming. As one witness cannot render him liable to make a monetary payment. In one stage, Rabbi Elazar, son of Rabbi Shimon, holds, when one witness comes to testify, it is to render the one against whom he is testifying liable to make a monetary payment, and that the reason is that he is coming. The Tanaim disagree whether denial by one witness constitutes a denial with regard to monetary matters. V'tizbera ha'amur ha'amar Abaya ha'kol moedim be'ed soita ve'kol moedim be'ed soita machloikes be'ed soita kol moedim be'ed echad ve'kol moedim be'ed shegenen chashud al Shevuot. The Gemara rejects this, and how can you understand the dispute in that way? Doesn't the bias say all concede with regard to a witness in the case of a sota that he is liable for taking a false oath of testimony, and all concede with regard to witnesses in the case of a sota? And there is a dispute with regard to witnesses in the case of a sota. All concede with regard to one witness that he is not liable for taking a false oath of testimony because he cannot render another liable to make a monetary payment, and all concede with regard to a witness testifying on behalf of the claimant when his counterpart, the defendant, is suspect about the oath. Ela d'chuli al ma'ad eid echad ki asi Shevuot asi v'hacha behakamiflegi mal savar davar goyrem limamon. The Gemara suggests, rather, all concede that when one witness comes to testify, it is to render the one against whom he is testifying liable to take an oath, and that is the reason he is coming. And here they disagree about this. One sage, Rabbi Elazar, son of Rabbi Shimon, holds a matter that causes financial loss is considered to have monetary value. Although the testimony of one witness does not render one liable for monetary payment, occasionally the party against whom he testified will prefer to pay rather than take the oath that the witness rendered him liable to take. In those cases, the testimony of one witness does in fact cause money to be paid, and one sage the first time holds a matter that causes financial loss is not considered to have money value. Gufa. With regard to the matter itself, Abaye says all concede with regard to a witness in the case of a sota that he is liable for taking a false oath of testimony, and all concede with regard to witnesses in the case of a sota, and there is a dispute with regard to witnesses in the case of a sota. All concede with regard to one witness, and all concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. Hakol moedim beit soid shechai be'ed tuma derchmana hemena dichsiv ve'ed in ba kol sheyesh ba. The Gemara elaborates all concede with regard to witness in the case of the sota that he is liable for taking the false oath of testimony. In the case of witness of impurity, this is referring to a case where the husband issues a warning to his wife in the presence of two witnesses that she may not enter into seclusion with a certain man, and witnesses testify that she entered into seclusion with him. And one witness testifies that she engaged in intercourse with that man, as in that case the merciful one accorded a credibility to the witness, as it is written with regard to the sota, and there is no witness against her. Numbers 5:13, that she engaged in intercourse. From that verse, it is derived that any witness that there is against her is sufficient to render her forbidden to her husband and enable him to divorce her without paying the sum stipulated in the marriage contract. Therefore, the witness who testified that she engaged in intercourse with that man is, for all intents and purposes, a witness to a monetary matter. All concede with regard to witnesses in the case of the sota that each witness is exempt from liability due to a false oath of testimony. This is referring to the case of witnesses of warning who testify that the jealous husband warned his wife not to enter into seclusion with a certain man, as each witness is the cause of financial loss, not a direct cause of that loss, in order to lose payment of her marriage contract. In addition to the witness of warning, witnesses of seclusion would also be required, after which either a witness would testify that she engaged in intercourse, or she would be required to drink the bitter water of a sota, either of which would confirm that she engaged in an adulterous relationship. And now we turn to 32b, top of the page. Machloikis Beidisoita, Machloikis Beidisoita, Lai 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 lai, Lai 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 lai, Lai lai lai, Machloikis Beidisoita. Weiter, alright, Machloikis Beidisoita. Beidistira, Marso, Dover Goel min Mamon. Kimamon dami, v'chayav, umar savar lav kimamon dami upaturu. I think we read this. Did we read this? There's a dispute with regard to witnesses in the case of the sota. I think you read it. We'll read it again. And there's a dispute with regard to witnesses in the case of a sota. This is referring to witnesses of seclusion. Maybe we didn't read it. Anyway, either way. This is referring to witnesses of seclusion who testify that a woman who was warned by her husband, in fact, entered into seclusion with the man in question. One sage, Rabbi Elazar, son of Rabbi Shimon, holds that a matter that causes financial loss is considered to have monetary value, and each witness is liable for taking a false oath of testimony, as had they testified, the woman would lose their marriage contract. And one sage, the rabbis, holds that a matter that causes financial loss is not considered to have monetary value and is exempt. Hakol moedim b'shekenegdo chashud al hashvua. Hakol moedim be'edechad d'Rabbi Abba. It is stated above further, all concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. All concede in the case of one witness, as in the incident with Rabbi Abba. Hakol moedim b'shekenegdo chashud ala shevua d'chashid man. Inem d'chashid lo ve'amar le malve says asahadat li hava mishtabana v'shakilna v'le'male mi'ema li mishtabat. The Gemara elaborates, all concede with regard to a witness testifying on behalf of the claimant when his counterpart is suspect about the oath. The testimony of one witness renders the borrower liable to take an oath that he does not owe money. The Gemara asks, in a case where who is suspect? If we say that the borrower who is denying the debt is suspect, and it is a case where the lender says to the witness, if you came and testified on my behalf, I would have taken an oath in taking the sum owed to me from the borrower since he is suspect with regard to oaths. Why would the witness be liable for taking a false oath of testimony? Let the witness say to the lender, who could say that you would have taken an oath? Since there is no certainty that he would have taken the oath, the witness is merely the cause of a loss, the cause of financial loss. Rather, it is a case where both the borrower and the lender are suspect, as the master says. Since both are suspect, the oath reverts to the one who is initially obligated to take it, meaning the borrower. And since he is unable to take the oath because he is suspect, he pays the entire claim to the lender. One witness rendered the borrower liable to pay the debt. Nasacha mechavere aser lekamed Rami haya yasiv Rabba kame azal aise chad sehada demichtaf chatva mine amarle in chatfi v'didi chatafi. Abaye said, all concede in the case of one witness, as in the incident with Rabbi Abba. What are the circumstances? As there was a certain man who snatched a silver ingot from another, and the one from whom it was taken, came before Rabbi Ami, and while Rabbi Abba was sitting before him, and went and brought one witness who testified that the defendant indeed snatched it from him. The one who snatched it said to him, yes, it is true that I snatched it, but I merely snatched that which was mine. Rabbi Ami, Heichel daine hadina yishalem leka tre sahadi lifatre ha ika chad zadat michtaf chatav ishtaba kevan damar in chatafi v'didi chatafi havele kegazlan amarle Rabbi Abba havele mechuyav shvua ve'enu yachol lishava v'chol hamechuyav shvua enu yachol lishava mishalem. Rabbi Ami said, how shall judges rule in this case? Let the judges require him to pay. But there are not two witnesses who witnessed the robbery. Let the judges rule to exempt him from payment. But there is one witness that he snatched the ingot. Based on the testimony of that witness, let the alleged robber take an oath that he did not snatch the ingot. But once he says, yes, I snatched it, but I merely snatched that which was mine, his halachic status is like that of a robber who is disqualified from taking an oath. But Abba said to him, he is one who is obligated to take an oath, but is unable to take an oath. And anyone who is obligated to take an oath, but is unable to take an oath, is liable to pay. In that case, were that witness to take a false oath and deny knowledge of the matter, he would be liable. Rav Papa says all concede with regard to the witness of a death that he is liable for taking an oath of testimony if he took a false oath and denied knowledge of the incident, and concede with regard to the witness of a death that he is exempt in that case. Gemara elaborates, all concede with regard to the witness of a death that he is exempt, where he said to the wife herself that her husband is dead, but he did not tell it to the court, and now he denies his earlier statement, as we learned in the Mishnah in Yehoshua 1:12. The woman who said, my husband died, shall remarry on the basis of her own testimony. Likewise, if she says, my husband died, she shall enter into levirate marriage with her brother-in-law on the basis of her own testimony. The fact that the witness subsequently denied knowledge of the matter does not cause her to lose her marriage contract, since she can come to the court and testify based on the statement of the witness and collect her marriage contract. Hakol moedim be'ed misashu chayav delo amar ledida velo amar lehu lebeit din. All concede with regard to the witness of the death that he is liable in a case where he did not say that the husband is dead to the wife herself, nor did he say it to the court. In that case, his denial of knowledge of the matter causes the wife to lose payment of her marriage contract. The Gemara asks, shall we conclude from here that according to Rav Papa, in the case of one who administers an oath to witnesses with regard to land, the witnesses are liable for taking a false oath of testimony, given that the marriage contract here is collected from land belonging to the husband. This matter is subject to a dispute between the sages on 73b. The Gemara answers, no proof may be cited from here, as perhaps Rav Papa is referring to a case where she seizes her husband's movable property as payment for her marriage contract. Therefore, this is not considered testimony with regard to land. Kafar echad Yehuda echad kule hashta ze achal ze itzarvayu kakaferi amar tarishut chayav v'shini batu kafar echad Yehuda echad bivayu. The Mishnah teaches if one of the two witnesses denied knowledge of the incident, and the other one admitted that he had knowledge and proceeded to testify, the one who denies knowledge of the incident is liable. The Gemara asks, why was it necessary to teach this halacha in the Mishnah? Now that in the previous case where the potential witnesses both denied knowledge of the matter, one after the other, you said the first is liable and the second is exempt. In a case where one denied knowledge and one admitted that he had knowledge and proceeded to testify, is it necessary to mention that the one who denied knowledge is liable? Lo yitzricha kegon shekafru shneihen וחזר אחד מהם ויהודה בתוך כדי דיבור והקמש מלן בתוך כדי דיבור כדיבור דמי. The Gemara answers no. It is necessary to state this halacha in a case where both of them denied knowledge of the matter, and one of them retracted his denial and admitted to knowledge of the matter with the time required for speaking a short phrase. And this teaches us that the halachic status of a pause or retraction within the time required for speaking a short phrase is like that of continuous speech. The Gemara asks, granted according to Chisda, who interprets the previous case in the Mishnah in which the two witnesses denied knowledge of the incidents. One, they are liable in accordance with the opinion of Yehoshua. A different halacha may be learned from each clause of the Mishnah. It is learned from the first clause that it is possible for two events to coincide precisely, and the latter clause was necessary to teach that the halachic status of a pause or retraction within the time required for speaking a short phrase is like that of continuous speech. But according to Yochanan, the halacha of within the time required for speaking a short phrase is learned from the first clause, and the halacha of within the time required for speaking a short phrase is learned from this latter clause. Why do I need two clauses to teach the same halacha? The Gemara answers, even according to Yochanan, both clauses are necessary, lest you say that this statement, the halachic status of a pause or retraction within the time frame required for speaking a short phrase is like that of continuous speech, applies only in a case where the first statement is a denial and the second statement is a denial. But in a case where the first statement is denial and the second statement is an admission, say that no, its halachic status is not like that of continuous speech, and one cannot admit knowledge after having denied it. Therefore, the Tana teaches us that even in a case where he retracts the denial and admits his knowledge, its halachic status is not like that of continuous speech. It is not like that of continuous speech. Okay? היו שתי קטעי עדים, כף ראשונה ואחר כך, כף השנייה, בשלב השנייה תחייב, תכף לראשונה, ראשונה עמי. The Mishnah teaches, if there were two sets of witnesses that took the oath of testimony, the first set denied knowledge of the matter, and thereafter the second denied knowledge of the matter, both sets of witnesses are liable. The Gemara asks, granted, the second set will be held liable since the first set denied knowledge of the matter. The ability of the plaintiff to collect his monetary claim is dependent exclusively on the second set, and their denial causes loss. But why is the first set liable?